A forensic expert with 30 years of experience just testified that the defendant was guilty beyond any doubt. 60 seconds later, he admitted under oath that he fabricated his entire resume. His credentials were fake. His methodology was fiction. And over 200 people he helped convict might be innocent. This is what happens when expert witnesses get exposed. And these 7 cross-examinations didn't just destroy testimony. They destroyed careers, overturned convictions, and changed American law forever. Expert witnesses are supposed to be the nuclear weapons of litigation. They're the PhDs, the board-certified specialists, the people with decades of experience who tell juries what to believe. Attorneys pay them anywhere from $500 to $15,000 per hour because their testimony can make or break a case. But here's what most people don't realize. The expert witness industry is a $2.5 billion business. And where there's that much money, there's corruption. What you're about to see are the moments when highly paid experts got caught. Not just caught being wrong. Caught lying. Caught fabricating. Caught saying whatever they were paid to say. And in one case, we'll reveal how a single cross-examination exposed a fraud so massive, it's still sending shockwaves through the legal system today. Our first case takes us to Texas, 1991. Cameron Todd Willingham sat on death row, convicted of murdering his 3 daughters by setting his house on fire. The prosecution's star witness was a fire investigator who testified with absolute certainty that the fire was arson. He pointed to pour patterns, crazed glass, and burn marks that he claimed proved accelerants were used. For 12 years, Willingham maintained his innocence. Then a new attorney hired Dr. Gerald Hurst, a renowned fire scientist, to review the evidence. What Hurst discovered would shake the foundation of fire investigation across America. Every single indicator the original experts cited as proof of arson. Modern science had debunked them all. The pour patterns. Flashover creates identical marks. The crazed glass. Caused by rapid cooling from firefighter hoses, not accelerants. Now let me stop here because this is where it gets infuriating. The original fire investigator wasn't just wrong. He was operating on folklore. See, fire investigation in the 1980s and 90s was based on myths passed down between investigators like ghost stories. No peer-reviewed science. No controlled experiments. Just because we've always done it this way. When confronted with the new evidence, you know what happened. Nothing. Texas executed Cameron Todd Willingham in 2004. The state's Forensic Science Commission later concluded that the testimony used to convict him was based on junk science. But here's the question that should haunt you. How many other experts are testifying right now using the same debunked methods? The answer is more than you'd ever want to believe. And that brings us to our next case, where an expert didn't just use bad science. He made it up entirely. Fred Zane worked as a serologist for the West Virginia State Police for 13 years. During that time, he was the prosecution's dream witness. Confident. Articulate. His testimony helped convict hundreds of defendants. Defense attorneys rarely challenged him. Why would they? He had the lab coat, the credentials, the state's backing. But in 1993, everything collapsed. A man named Glendale Woodall had been convicted of kidnapping and sexual assault based almost entirely on Zane's testimony. Woodall requested DNA testing, which was becoming available for the first time. The results proved Woodall was innocent. But the investigation didn't stop there. Auditors discovered something that defies belief. Fred Zane had been falsifying results for over a decade. He reported test results for tests he never performed. He contaminated samples. He altered evidence. And when the numbers didn't match what prosecutors wanted, he simply made up new numbers. The West Virginia Supreme Court eventually ruled that any case involving Zane's testimony was presumptively invalid. Let that sink in. Every single case. An independent audit suggested at least 134 defendants may have been wrongfully convicted. Some had already served decades in prison. Others had died there. When Glendale Woodall's attorneys finally got Zane on the stand for a civil deposition, they didn't just cross-examine him. They systematically dismantled his entire career. They presented his own lab notes showing tests he claimed to have run on days the equipment was broken. They showed blood samples he analyzed that contained no blood. They revealed that he reported blood type results that were statistically impossible. With each question, Zane's composed exterior cracked further. But the most devastating moment was still coming. And it would expose not just Zane, but the entire system that protected him. But here's what they never tell you in the documentaries. Fred Zane didn't act alone. And this is where everything you think you know about expert witness fraud gets turned upside down. When investigators dug deeper, they found that supervisors had received complaints about Zane for years. They knew his work was questionable. But prosecutions were succeeding. Conviction rates were up. So they looked the other way. When Zane left West Virginia for Texas, they gave him a glowing recommendation. He went on to work for the Behar County Medical Examiner's Office. More cases. More falsified results. More innocent people behind bars. The cross-examination that finally brought him down didn't just expose one corrupt expert. It exposed an entire ecosystem that prioritizes convictions over truth. And the expert witness disasters we've seen so far. They're nothing compared to what happened in Massachusetts. Because there, one chemist's fraud didn't just affect hundreds of cases. It affected over 40,000. Annie Ducon was a chemist at the Hinton State Laboratory in Massachusetts. For nearly a decade, she was considered a superstar. While other chemists tested between 50 and 150 samples monthly, Ducon claimed to test over 500. Prosecutors loved her. She was fast, reliable, and always gave them the results they needed. Defense attorneys started noticing something strange. Ducon always seemed to confirm the prosecution's assumptions. Samples that other chemists found inconclusive, Ducon found positive. When attorney Luke Ryan began investigating, what he uncovered was catastrophic. Ducon wasn't testing most of the samples at all. She admitted to dry labbing, which means reporting results without performing actual tests. She would look at a substance, guess what it was, and write that down as scientific fact. She added drugs to samples that tested negative to make them test positive. She forged colleagues' signatures on documents. When Ducon finally faced cross-examination, her entire facade collapsed in spectacular fashion. Defense attorney John Cunha presented her with her own lab records. He showed her that she had certified testing more samples in some months than there were working hours to test them. She would have needed to complete one test every 63 seconds, 8 hours a day, with no breaks. Impossible. Then came the emails. Prosecutors had been sending Ducon messages asking, quote, "What's the best way to prove this is cocaine?" end quote. She replied with specific instructions on what evidence to submit. She wasn't just a corrupt scientist. She was coaching prosecutors on how to manufacture cases. The aftermath was staggering. Over 23,000 convictions were eventually dismissed. It remains the largest mass dismissal in American legal history. People had lost jobs, homes, custody of children. Some had been deported. And every single outcome was based on one expert's fabricated testimony. Now I need you to understand something. Everything I've shown you involves criminal cases. But expert witness fraud happens in civil cases too. And the money involved makes criminal fraud look like pocket change. Think about it. What would you have done if you were a juror in these cases? You trusted the expert. You relied on their testimony. You sent people to prison. And now you discover it was all lies. This brings us to the civil case that changed how courts handle experts forever. It's called Daubert vs. Merrill Dow Pharmaceuticals. And the cross-examination at its center didn't just expose one expert. It forced the United States Supreme Court to completely rewrite the rules for expert testimony. The standard they created is still used in every federal courtroom today. But even that wasn't enough to prevent what happened next. Because some experts have figured out how to game even the strictest standards. The Daubert case involved children born with birth defects whose mothers had taken an anti-nausea medication during pregnancy. The plaintiff's expert witnesses testified that the drug caused the defects. But under cross-examination, defense attorneys revealed something crucial. The experts hadn't published their methodology. They hadn't subjected it to peer review. Their conclusions contradicted every published study on the medication. The trial judge threw out their testimony. The Supreme Court upheld that decision and created a new standard. Under Daubert, judges must act as gatekeepers. They must evaluate whether expert testimony is based on sufficient facts, reliable methods, and proper application of those methods. It sounds foolproof. It isn't. Because what happened at the Massachusetts Crime Lab, what Fred Zane did for 13 years. All of it occurred after Daubert. The standard only works if someone actually challenges the expert. And that brings us to the most disturbing cross-examination you'll see today. His name was Dr. Charles Smith. For 20 years, he was Canada's most trusted pediatric forensic pathologist. He testified in over 1,000 cases involving the deaths of children. Parents went to prison based on his word. And then defense attorney James Lockyer began reviewing his cases. What he found was devastating. Smith had no formal training in forensic pathology. He had never published peer-reviewed research. He performed autopsies using methods he invented himself. When Lockyer finally got Smith on the stand in 2007, the cross-examination was surgical. He presented case after case where Smith had testified with certainty about causes of death that other experts found inconclusive or completely different. He showed that Smith had kept evidence in his basement, violating every chain of custody protocol. He revealed that Smith had changed his conclusions when prosecutors asked him to. By the end, Smith admitted he had made mistakes that sent innocent parents to prison for killing children they never harmed. 13 wrongful convictions were eventually overturned. And here's the revelation that ties everything together. In every single case we've discussed today, the expert was exposed not by the system designed to catch them, but by defense attorneys who refused to accept the official story. The gatekeepers failed. The peer review failed. The oversight failed. The only thing that worked was relentless, devastating cross-examination. So what does this mean for you? It means that every time you see an expert witness on television confidently testifying about blood splatter or fire patterns or DNA, remember this. Their credentials might be fabricated. Their methods might be folklore. Their conclusions might be whatever the side paying them wants to hear. The expert witness system is broken. Daubert helps. Better forensic standards help. But the real safeguard is skepticism. It's attorneys willing to dig into every claim. It's jurors who ask whether the science is sound, not just whether the expert sounds confident. Over 50,000 cases have been affected by the frauds we discussed today. 50,000. And those are just the ones we know about. How many more experts are still testifying right now, using methods no one has challenged, with credentials no one has verified? That question keeps defense attorneys up at night. After watching this video, it should concern you too. Now you know what happens when expert witnesses get exposed. If you found this breakdown valuable, hit subscribe because next week we're revealing the 5 interrogation techniques police use that have been proven to produce false confessions. Same problem, different side of the courtroom. Before you go, tell me in the comments, which of these cases shocked you the most? Was it the fire investigator whose folklore sent a man to death row? The chemist who manufactured evidence in 40,000 cases? Or the pathologist who imprisoned innocent parents? Drop your answer below. I read every comment.